Welcome to the deep dive. We take source materials, could be articles, research, even our notes, and pull out the key insights for you. This is part of our ongoing series working through the MPP, the Patent Office's manual, section by section.
Right, making those dense rules a bit more accessible. And today we're tackling MPP Section 605. The title is simple, Applicant. It's in Chapter 600, which covers the application itself, parts, form, content.
Okay, applicant. Seems simple enough. Who can apply for a patent? But like a lot of things in patent law, I get the feeling it's not quite that straightforward.
You're absolutely right. It seems simple, but the rules have layers, and they've changed. Who can be the applicant really depends on some key factors, especially when the application was filed.
Ah, okay. So our mission today is to unpack Section 605, figure out who can be the applicant, how that might change, and I guess why it's so important to get this right.
Exactly. It's not just filling in a name on a form. Getting the applicant designation correct is critical for the whole process, from filing to enforcement. We'll use the MPP section itself as our guide.
All right, let's start at square one. When someone files a patent application, who's typically listed as the applicant initially?
Well, the default, kind of the starting point laid out in the regulations, like 37 CFR section 1.42, is the inventor, or inventors if they're multiple.
Yeah.
They created it, right?
Makes sense.
But importantly, the law also allows other people or entities to be named as the applicant. It's not just the inventor.
And this is where that key factor comes in, the timing. You mentioned a date.
Precisely. The landscape completely changes depending on one critical date, September 16, 2012.
Okay. September 16, 2012. What happened then?
That's when major parts of the American Invents Act, the AIA, kicked in. And the rules for who can be the applicant are, well, fundamentally different if your application was filed before that date versus on or after it. It's a huge dividing line.
Got it. So let's talk pre-AIA first. Before September 16, 2012, if I invented something then, who had to be the applicant?
For those older pre-AIA applications, the rule was very strict. The inventor must be the applicant, period.
Wait, even if I worked for a company and signed away my rights in my employment contract, the company owned the invention, but I still had to be the applicant on the paperwork.
Exactly that. Even if you'd already assigned your rights, maybe to your employer or someone who bought the invention, you, the person who actually invented it, had to be named as the applicant on the initial filing papers.
Huh. So the company couldn't file in its own name?
No, not as the applicant. Now, the company, the assignee, could take over prosecuting the application. They could interact with the patent office, but they had to follow specific procedures like recording the assignment properly to show they had the right to act on the inventor's behalf. The focus was really on the inventor personally applying.
Okay, that historical context helps. Now let's jump forward. Post-AIA. Applications filed on or after September 16th, 2012. How did the AIA change things? This is where it gets more flexible, right?
Yes, this is where it really opens up, and frankly, better reflects how inventions often come about and are owned today. Under the current rules, post-AIA, the applicant can still be the inventor or inventors. That hasn't changed.
Okay.
And this is the big shift. It can also be the party who actually owns the invention through an assignment. That's called the assignee.
So the company that owns it can now be the applicant directly?
Yes, or it could be someone the inventor is obligated to assign the invention to. Think employment agreements again, or maybe a research contract.
Ah, okay. Even if the assignment hasn't officially happened yet, but there's a legal obligation.
Correct. And there's even another category, a party that can show they have a sufficient proprietary interest in the invention. The rules provide a way for them to apply too.
Wow, okay. So sufficient proprietary interest, that sounds a bit vague. How does that work? And how does the company or the assignee actually do this? Do they just write their name on the form?
It's not quite that simple, but it's definitely streamlined compared to before. If a non-inventor, like an assignee or someone with that obligation or interest, wants to be the applicant, they need to follow specific procedures set out in the rules, like 37 CFR section 1.46.
Procedures like what?
Usually it involves submitting documentation along with the application, typically using something called the application data sheet, or ADS. This sheet identifies who the applicant is. If it's not the inventor, you generally need to provide evidence of the assignment or a statement explaining the obligation or the proprietary interest. Basically, you have to show the USPTO why you have the right to file as the applicant instead of the inventor.
So it's about proving your standing, showing that paper trail.
Exactly. It connects the ownership or the right to own directly to the application filing itself. It aligns the process much more closely with the business reality.
The source material gives some good examples, like a startup employee.
Right. Say an employee invents something, And their contract clearly states inventions belong to the company and must be assigned. That startup, assuming the assignment paperwork is handled correctly, can file the patent application directly, listing the company as the applicant, not the employee.
Makes sense. What about trickier situations, like if the inventor passed away?
That's covered too. If an inventor is deceased, or maybe legally incapacitated, their legal representative, like the executor of their will or a court-appointed guardian, can step in. They can file the application and act as the applicant on behalf of the inventor's estate. There are specific rules, like 37 CFR 1.43, and documentation needed for that.
And the university example. If a professor invents something under a university research agreement.
Similar idea. If the inventor is contractually obligated to assign the invention to the university can be named as the applicant right from the start, provided they submit the right documentation showing that obligation. It just reflects who really have the controlling interest.
It really does seem to streamline things based on ownership. Now, what if there's more than one inventor? Joint inventors. Do they all need to sign off?
Generally, yes. For joint inventors, the standard rule is they apply together. They're all listed, or if a company's the applicant, the company's standing comes from all of them.
But what if one inventor just disappears or refuses to cooperate?
Yeah, that happens. The law anticipates this. If a co-inventor genuinely can't be found after diligent effort, or if they just refuse to join in filing the application, the other inventor, or the assignee, if there is one, aren't stuck. They can still file.
How?
They use something called the substitute statement. It's basically a document explaining the situation, why the one inventor isn't participating. This prevents one person from unfairly blocking the patent process for everyone else involved.
That seems fair. Okay, so that covers who can start as the applicant. What about changes during the process? After filing, while the application is being examined, can the applicant change?
Absolutely. Ownership can change hands. Company names can change. Section 605 addresses this too. For simple things, like fixing a typo in the applicant's name or the company officially changes its name, it's usually straightforward.
How straightforward?
You typically just need to file an updated application data sheet, that ADS form again, making the correction. But crucially, you need to do this before you pay the issue fee, right before the patent is granted.
Okay, minor fixes are manageable. But what if it's a bigger change, like the whole application gets sold to a different company mid-prosecution?
Right, a complete change in who the applicant is because ownership is transferred, that requires more formal steps. The new owner, the new assignee, needs to properly record the assignment document with the USPTO. Then, they need to follow procedures outlined in rules like 37 CFR 3.71 and 3.73 to establish their right to take over prosecution.
So more paperwork to prove the change in ownership and control.
Exactly. The Patent Office needs a crystal clear record of who owns the rights and who is legally entitled to make decisions about the application, like responding to the examiner, making amendments, or deciding to appeal.
It sounds like maintaining that clear chain of title is paramount.
It really is. And speaking of companies being applicants, there's another point for post-AIA. If the applicant is a juristic entity, basically, a corporation or other legal entity, not a person, they must be represented by a registered patent attorney or agent. They can't just represent themselves pro se, like an individual inventor sometimes can.
Okay, that's an important detail for businesses. So we've covered who can be the applicant, pre and post AIA, and how to change it. Now let's get back to the why. Why does all this matter so much? It feels like more than just administrative correctness.
Oh, it absolutely is. Getting the applicant and ownership right isn't just ticking a dox. It has real substantive impact on the patent process and the resulting patent's validity and enforceability. It affects several key areas.
Like what? Give us the big ones.
Okay, first, a really big one. Prior art. Who the applicant is and who owns related inventions can directly affect whether certain previous disclosures count as prior art against your application.
How so?
Under the AIA, there are exceptions. For instance, subject matter disclosed before your filing date might not be counted as prior art if it was developed by the same inventor or was commonly owned, or subject to a joint research agreement around the time your invention was made. Knowing the applicant owner status is crucial to see if you qualify for these exceptions. It can literally save your patent application.
Wow. Okay, that's huge. What else?
Second, the duty of disclosure. Everyone involved in filing and prosecuting a patent application has a duty to tell the USPTO about any information they know of that's material to patentability. This duty isn't just on the inventor. It explicitly extends to the applicant, including assignees. So if a company is the applicant, the company itself, and individuals within it involved in the process carry that legal duty.
So the burden shifts or expands depending on who the applicant is.
Got it.
Number 3.
Third, fees. Your eligibility for reduced patent fees. Small entity or micro-entity status depends on the status of the applicant or the owner. A university might qualify as a nonprofit small entity, saving significant money, but if they assign it to a large corporation, that status is lost. Getting the entity status wrong can jeopardize the patent later on, and maintenance fees, paid after the patent grants, are the responsibility of the current owner.
Right. Fees are always important. What else?
And finally, just the basic ability to take action. Only the properly identified applicant or the owner who's properly recorded their rights can legally interact with the USPTO. They're the ones who sign responses, file appeals, pay the issue fee, authorize amendments. If the person trying to act isn't recognized by the USPTO as the proper party in interest, their actions might be ignored, leading to delays or even abandonment.
Okay, so it touches everything. Prior art strategy, legal obligations, costs, and just the fundamental ability to move the application forward. Understanding MPEP 605 is clearly not optional.
Not at all. It's foundational. Section 605 provides this framework. It's flexible, especially post-AIA, to handle inventors, companies, estates, you name it. But that flexibility comes with strict procedural requirements. You need the right forms, the right documentation, filed at the right time.
So, the bottom line is, know the rules for who can be the applicant based on your filing date, follow the procedures meticulously, especially if it's not the inventor applying, and keep the records updated if ownership changes.
That sums it up perfectly. It balances legal formality with the practicalities of how inventions are actually owned and managed, but you have to follow the steps to keep everything valid and enforceable.
Fantastic. That really clarifies the importance of just one section, MPEP Section 605 Applicant. We've seen how the rules evolved with the AIA and why knowing who the applicant is impacts so much. And a big thank you, as always, to Mike Shepard, our creative director who puts this whole MPP series together.
Yes, thanks, Mike. And now, our necessary disclaimer. This summary was put together using AI tools like ChatGPT and NotebookLM based on the MPP section. It's for educational purposes only. It's not legal advice, definitely not a substitute for reading the official MPP or getting formal instruction. There might be errors.
Absolutely. For anything authoritative, you need to consult the official MPP, talk to a qualified instructor, or, of course, speak with a registered patent practitioner.
Couldn't agree more.
So, to leave you with something to think about, after hearing all this, what really strikes you about these applicant rules? How do you think that big shift post-AIA, letting companies be the applicant directly, might change, or maybe already has changed the way innovation happens or how patents are treated as business assets compared to the old inventor-focused system? And on a practical level, what are the real hurdles companies face in managing complex ownership, maybe multiple inventors, partial assignments, and making sure they navigate all these USPTO procedures correctly? Lots to chew on there.